Please subscribe to the channel to watch the latest videos.
Supreme Court agrees to review gun rights challenge to bump stock ban. The Supreme Court said Friday that it would review a challenge to the federal ban on bump stocks announced by the Trump administration after the devices were used in a 2017 mass killing on the Las Vegas Strip. The Biden administration had asked the Supreme Court to reverse a lower court ruling against the ban on the devices, which speed up how quickly bullets can be fired when attached to rifles. Solicitor General Elizabeth B. Prelogar told the justices that the lower court decision threatens significant harm to public safety. Bump stocks, she said, fit the legal definition of machine guns, banned since 1986, because the devices allow a shooter to fire hundreds of bullets a minute by a single pull of the trigger. Like other machine guns, rifles modified with bump stocks are exceedingly dangerous. Congress prohibited the possession of such weapons for good reason. Attorneys for Michael Cargill, who challenged the ban after he was forced to surrender the devices in 2019, told the court that the bump stocks are useful for individuals with limited finger dexterity and noted that for nearly a decade, the federal government did not classify the devices as machine guns. Americans bought 520,000 bump stocks during the period in which the Bureau of Alcohol, Tobacco, Firearms and Explosives allowed them. The rule requires owners to either surrender or destroy devices they lawfully obtained. Those, like Cargill, who have already surrendered their bump stocks will never recover them if the rule stands. ATF admits that the expected loss of property will exceed $100 million, Cargill's attorneys said. The Supreme Court's acceptance of the case in a brief order on Friday means it will be heard and decided sometime this term, which ends in June. In October 2017, a gunman firing from a hotel near an outdoor country music festival on the Las Vegas Strip killed 58 people and wounded hundreds more before killing himself. Bump stocks found in the shooter's hotel room enabled him to fire hundreds of bullets into a crowd in minutes. The mass killing prompted then-President Donald Trump to announce that he had signed an order directing the Justice Department to change regulations to ban the devices starting in 2019. ATF amended the regulations and reclassified bump stocks as machine guns under the best interpretation of the statute. The rules were changed before the Supreme Court's significant 2022 decision on gun laws, which found a constitutional right to carry firearms outside the home and called into question other gun restrictions that did not have historical precedent. The justices are set to hear another Second Amendment case next week involving a challenge to a federal law that prohibits a person subject to a domestic violence restraining order from possessing a firearm. The challenge is based in part on the 2022 Supreme Court ruling. The bump stock ban was appealed to the Supreme Court before, after 3 appeals courts rejected challenges to ATF's final rule, but the justices did not agree to take any of those cases. This time, a district court and a unanimous panel of the U.S. Court of Appeals for the Fifth Circuit upheld the ban. After rehearing by a full complement of judges, the Fifth Circuit reversed in a fractured ruling. The Justice Department then asked the Supreme Court to intervene. Supreme Court weighs impact of gun ruling on domestic abuse protections. Latest Supreme Court gun case asks whether 2022 Bruin decision means violent domestic abusers can have weapons. Supreme Court cases often come with sympathetic protagonists, longtime devoted partners who want to celebrate their love with marriage, or devout people of faith who say government policies keep them from living out their beliefs. But in a major Second Amendment case that comes before the Supreme Court Tuesday, the Biden administration presents an almost textbook anti-hero in defending a federal law that bars people who are under domestic violence restraining orders from possessing firearms. Zakki Rahimi's transgressions with guns, detailed in the government's brief, range from the terrifying shooting at a witness who saw Rahimi drag his child's mother by her hair into his car, to the bewildering firing a few rounds into the air outside a Whataburger when his friend's credit card was rejected. When Rahimi was arrested at his Texas home in early 2021, the government says officers found a .45 caliber pistol, a .308 caliber rifle, magazines, ammunition, and a copy of the protective order a judge had issued that forbade him from possessing firearms. In her brief, U.S. Solicitor General Elizabeth B. Prelogar reminded the court of something it recognized in a 2014 case: the only difference between a battered woman and a dead woman is the presence of a gun. but it is a Supreme Court decision of more recent vintage that the court will be examining Tuesday. The justices will for the first time take an extensive look at the fallout from their 2022 decision in New York State Rifle and Pistol Association v. Bruin, which requires the government to point to historical analogs when defending laws that limit Second Amendment rights. The decision has created considerable churn in lower courts, with dozens of gun control laws declared suspect as a result of the justices' new test. The Rahimi case asks a pointed question of the conservative justices who formed the Bruin majority: does their test mean Congress might lack the authority to disarm those who are under domestic violence protection orders? Gun rights advocates concede the combination of the issue at hand, the universally lauded attempt to protect domestic abuse victims, and an unsympathetic defendant creates a better climate for the government than it sometimes faces at the Supreme Court, especially when the issue is gun control. It's certainly not the case I would have picked to go to the Supreme Court as the first review after Bruin, said Clark M. Neely III, Senior Vice President for Legal Studies at the Libertarian Cato Institute, which has strongly advocated Second Amendment rights. But look, public interest litigation 101 is you try to position the case in a way that is as sympathetic for your side as is possible. I don't know whether the DOJ sequenced the Rahimi case strategically, but if they did, hats off to them. Neely was part of the team behind the lawsuit that led to District of Columbia v. Heller, the landmark 2008 decision that established a Second Amendment right of gun ownership for individuals. Among his clients was Dick Heller, who carried a gun in his job as a security officer in federal buildings, but was forbidden from keeping one for personal protection in his home. Neely has filed an amicus brief supporting the U.S. Court of Appeals for the Fifth Circuit's decision for Rahimi that ruled unconstitutional the federal statute barring gun possession by those subject to civil protective orders. His brief says the law does not provide adequate due process before suspending someone's Second Amendment rights. Congress could fix the law, he wrote, but it is not the court's role to do so. Notably, Neely's brief never mentions the subject of the case by name. Rahimi, Neely said in an interview, seems to be someone who you wouldn't want running around with guns, and I wouldn't want running around with guns. The unanimous Fifth Circuit panel conceded Rahimi was hardly a model citizen, although his criminal record at the time the protective order was issued was scant. The judges found Rahimi was among those whose right to a weapon is protected by the Second Amendment, and rejected the historical comparisons advanced by the government to justify the law. Preventing domestic abuse was doubtless a salutary policy goal, added Judge Corey T. Wilson, who was nominated by President Donald Trump. But the government's logic about disarming rule-breakers had no limit, he said. Could speeders be stripped of their right to keep and bear arms, he proposed. Political nonconformists? People who do not recycle or drive an electric vehicle? The allegations against Rahimi, of course, were far more serious. And his alleged crimes did not end with the 2019 violent encounter with his ex-girlfriend, who escaped Rahimi's car when he was firing at the bystander. He later called her and threatened to shoot her if she told anyone about the assault. A Texas court considering the woman's request for a protective found that Rahimi had committed family violence and that such violence was likely to occur again in the future. The civil order suspended his gun license, prohibited him from possessing a firearm and warned him that possessing a firearm while the order remained in effect may be a federal felony. It apparently did not have the desired effect. In her brief, Prelogar said Rahimi subsequently threatened a different woman with a gun, leading to state charges. Then, in the space of 2 months, he opened fire in public 5 times. He is alleged to have shot at the driver in the other car after an accident Rahimi caused, the records showed. Rahimi currently is in jail in Fort Worth awaiting trial on some of the state charges that arose from the alleged assaults. Federal Public Defender J. Matthew Wright declined to comment on his client's behalf, but said in a brief to the Supreme Court that the only relevant events in the proceedings are the protective order issued February 5, 2020, and the subsequent discovery of a handgun and a rifle in Rahimi's room on January 14, 2021. Everything else is disputed and irrelevant to his guilt or innocence under the law, the brief states. Rahimi initially pleaded guilty to the federal charges and was sentenced to 6 years in prison. The appeals court first affirmed his sentence, but after the Supreme Court's Bruin ruling, it withdrew its original opinion. In Bruin, the justices voted 6-3 to strike down a century-old New York state law requiring a special need to carry a firearm outside the home. Justice Clarence Thomas, writing for the majority, said government officials cannot justify restrictions on firearms based solely on an important interest such as public safety concerns. Instead, he wrote, officials must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. The analogy does not have to be a twin, the court ruled, but must be relevant. Courts should not uphold every modern law that remotely resembles a historical analog, because doing so risks endorsing outliers that our ancestors would never have accepted, Thomas wrote. The decision has imperiled all types of gun regulations and left lower court judges divided over how to evaluate long-standing restrictions, in some cases asking whether they should call on historians to help. But the Fifth Circuit panel said it was clear the federal statute's ban on gun possession because of a civil protective order went too far. The Fifth Circuit swept away the historical analogies the government offered in defense of the federal law. And in a concurring opinion, Judge James C. Ho said the statute was difficult to justify because it disarms individuals based on civil protective orders rather than criminal proceedings. Wright, in his Supreme Court brief on Rahimi's behalf, said Bruin makes this an easy case. The gun possession ban in the federal law arises not from a criminal conviction but from a civil state court order, often after a one-sided proceeding, Wright wrote, adding whatever the founding generation believed about state and local legislatures' power to restrict firearm ownership, they would have resisted a federal law purporting to say which citizens could, and which citizens could not, keep firearms. Prelogar replied that the idea Congress is powerless to restrict firearm possession by domestic abusers and other categories of dangerous individuals defies precedent, history, and common sense. The government's position in the case is supported by a wide array of states, localities, domestic violence prevention groups, and gun control activists. They provide dire warnings. Every month, an average of 70 women are shot and killed by an intimate partner, said a brief filed by the group Everytown for Gun Safety. And access to a gun makes it 5 times more likely that a woman will die at the hands of her abuser. The lesson that Prelogar says should be drawn from the court's decisions in Heller and Bruin is that the Second Amendment protects law-abiding, responsible citizens and allows disarming those who have been shown not to be. The phrase law-abiding, responsible citizens appears 40 times in the government's brief. Such a broad rule seems at odds with a court majority that lately has been more skeptical of gun control measures. But it could also be cast with an eye toward future challenges. The court on Friday said it would review the federal ban on bump stocks announced by the Trump administration after the devices were used in a 2017 mass shooting on the Las Vegas Strip. And waiting in the wings at the Supreme Court are other challenges to federal bans on gun possession by those who have been convicted of nonviolent felonies and by habitual drug users. A law that helped end slavery is now a weapon to end affirmative action. The Civil Rights Act of 1866 has become a critical tool in conservatives' fight to end racial considerations in the private sector. After Congress passed the Civil Rights Act of 1866, establishing citizenship for newly emancipated slaves, President Andrew Johnson vetoed it, voicing concern that it was made to operate in favor of the colored and against the white race. But lawmakers overrode his veto, enacting one of the nation's first building blocks of an equal society. Now, 157 years later, the law has become central to the legal battle over what is fair and equal when it comes to race in the workplace. In recent years, and especially since the Supreme Court overturned race-conscious college admissions in June, the Reconstruction-era law has emerged as a critical tool for conservatives intent on dismantling race-specific programs that promote diversity, equity, and inclusion, or DEI. More than a dozen lawsuits, nearly all filed within the past 3 years, use the law to allege reverse discrimination. The plaintiffs include former employees at major companies, small business owners, government contractors, college undergraduates, and conservative activists. All say they're fighting for a colorblind society, and that programs intended to bolster economic participation for certain racial and ethnic groups have unfairly shut out whites and, in some cases, Asians. Critics call these claims a perversion of the law's original intent. It's ironic, they say, that legislation meant to grant former slaves basic civil rights, and make it illegal to deprive them of those rights because of their race or color, is being used to stifle advancement by Black and minority professionals and entrepreneurs in industries in which they have long been underrepresented. Moreover, affirmative action was meant to redress centuries of discrimination, not punish whites or Asians. Even with such programs, people of color are vastly underrepresented in the top tiers of the business world. There are only 8 Black CEOs among Fortune 500 companies, the highest number since the list started in 1955. And of the $214 billion in venture capital funding allocated in 2022, a scant 1.1% went to companies with Black founders, according to Crunchbase. Whatever happens, the law's disparate applications mirror the nation's fitful civil rights history. A recent wave of reverse discrimination lawsuits could prohibit the private sector from using race-based affirmative action and DEI programs in light of the Supreme Court's finding that race-conscious admissions programs at Harvard University and the University of North Carolina contradicted constitutional promises of equal protection forged after the Civil War. "That'll be an easy case for the High Court's conservative majority," said Michael J. Klarman, a professor of legal history at Harvard Law School. "And they're not interested in arguments that recent application of such laws is unbelievably perverse." Listed as Section 1981 in the Federal Code, the 1866 law has been cited in lawsuits against Pfizer, Morgan Stanley, Amazon, Gannett, a pair of global law firms and a venture capital fund for women of color. All challenge the use of racial preferences, whether in deciding who to hire, selecting contractors, or awarding fellowships. John Yoo, a law professor at the University of California at Berkeley who sits on the board of the conservative Pacific Legal Foundation, rejects the idea that such lawsuits distort the intent of the Civil Rights Act of 1866. "Lawmakers didn't write the text of the statute to be limited in time or to protect only one race," he said. Black codes. When the 13th Amendment outlawed slavery in 1865, it left the newly emancipated in legal limbo because a slave was not a person in the contemplation of the law, wrote New York lawyer Robert L. Cole in a 1969 Virginia Law Review article. He had no personal or civil rights. This ambiguity created an array of legal disabilities, leaving the newly freed without the right to marry, inherit property, or take legal action. It also gave rise to a patchwork of black codes in the South, laws meant to oppress and control them. The whites know that if Negroes are not allowed to acquire property or become landowners, they must ultimately return to plantation labor and work for wages that will barely support themselves and families, and they feel that this kind of slavery will be better than none at all, wrote a Freedmen's Bureau official in a letter included in the 1865 report to Congress on the condition of the South. The Black Codes purported to be about protecting the rights of Black people, but they were actually a way of functionally re-enslaving them by requiring them to sign contracts, Klarman said. If they didn't sign contracts, they'd be treated as vagrants. If they're vagrants, they would be arrested and then sold off essentially to the highest agricultural bidder. The Civil Rights Act of 1866 was partly a response to the Black Codes, as well as to the legal disabilities. It guaranteed a bevy of rights, equal to those enjoyed by white citizens, including the ability to buy and sell property, sue and be sued, provide evidence, and make and enforce contracts. In short, the law was meant to address the question of citizenship for the formerly enslaved, said George Rutherglen, a law professor at the University of Virginia. And the statute answers the question: they're going to be treated just like white citizens. 2 years later, Congress passed the 14th Amendment, guaranteeing citizenship to anyone born or naturalized in the United States, including formerly enslaved people, ensuring equal protection under the law. Both measures were seen as a radical remaking of American society, Rutherglen said. But enforcement fell away soon after the federal government pulled its soldiers out of southern states in the late 1870s. Then Jim Crow laws took hold, ushering in a strict system of racial segregation that stretched far into the next century. Whites as well as non-whites. The 1866 Civil Rights Act faded into obscurity for nearly 100 years, until an interracial couple tried to buy a home in St. Louis in 1965. That June, Joseph Lee Jones, who was Black, and his wife, Barbara Jo Jones, who was white, were advised by a real estate agent for the Alfred H. Mayer Company that it was the company's general policy not to sell houses and lots to Negroes. The couple sued, citing the law, and the case reached the Supreme Court in April 1968. Justices, who heard arguments days before the assassination of the Reverend Martin Luther King Jr., ruled 7-2 in Jones's favor, holding that private parties could not discriminate against black people in the sale of property. Legal historians say the 1866 Civil Rights Act was revived by the Jones decision, which interpreted the law as one prohibiting discrimination by private parties. Nearly a decade later, two white men used it to claim discrimination. The 1976 landmark case involved white workers Ellen McDonald and Raymond Laird, and a black colleague, Charles Jackson, who had been charged with stealing 60 gallons of antifreeze being transported by the Santa Fe Trail Transportation Company. While Jackson was allowed to keep his job, Laird and McDonald were fired. They sued, alleging discrimination under the 1866 Civil Rights Statute, and their case landed before the Supreme Court. The court ruled 7-2 in their favor. Writing for the majority, Thurgood Marshall, the first black Supreme Court justice and a legendary civil rights figure, said the law was intended to apply to all persons, including white people. The context of emancipation notwithstanding, the general discussion of the scope of the bill did not circumscribe its broad language to that limited goal, Marshall wrote in McDonald v. Santa Fe Trail Transp. Company. On the contrary, the bill was routinely viewed, by its opponents and supporters alike, as applying to the civil rights of whites as well as non-whites. It is this interpretation that gives the 1866 Civil Rights Act so much power in the present campaign to end private sector affirmative action programs, experts say. The Fearless Fund. Most reverse discrimination lawsuits citing the 1866 law concern fellowship or grant programs restricted to specific underrepresented groups. That includes one filed in August by America First Legal, a legal nonprofit founded by former Trump administration advisor Stephen Miller, against Progressive Insurance's Small Business Forward Fund, which awards $25,000 grants to black-owned businesses. The group also has alleged that a small business accelerator program run by Amazon discriminates against whites. Amazon founder Jeff Bezos owns the Washington Post. Interim chief executive Patty Stonecipher sits on Amazon's board. But these arguments have perhaps most vividly played out in a case against the Atlanta-based Fearless Fund, a venture capital firm for women of color. In August, a group led by affirmative action opponent Edward Blum, the driving force in the Harvard and UNC lawsuits, sued the fund alleging that its $20,000 grant program for black female entrepreneurs discriminates on the basis of race, a violation of the 1866 Civil Rights Act. In September, a panel on the U.S. Court of Appeals for the 11th Circuit temporarily blocked the grant process from moving forward, ruling that it would likely violate the law. The 11th Circuit is expected to rule on whether the fund can proceed with its grant program as the court case is litigated. Blum, reacting to a lower court's decision in September, said that the nation's civil rights laws do not permit racial distinctions because some groups are overrepresented in various endeavors, while others are underrepresented. But critics insist that Blum and others driving similar challenges have distorted the law's intent, wielding it as a cudgel against fair opportunity for racial minorities, especially black people. This is a seminal civil rights statute, passed right after the Civil War, to ensure that the newly freed people who were slaves have the same rights as everybody else, Jason Schwartz, a lawyer with Gibson Dunn, a law firm defending the Fearless Fund, said in a recent interview. And to try to use that statute as a weapon against black people is outrageous. Judge Charles R. Wilson, who was appointed to the 11th Circuit by President Bill Clinton, made a similar argument in his September dissent from an appellate panel's decision to temporarily halt the Fearless Fund's grant program. It is a perversion of congressional intent to use the law against a remedial program whose purpose is to bridge the gap in venture capital funding for women of color founders, a gap that is the result of centuries of intentional racial discrimination, he wrote. But the two other judges on the panel, Robert J. Luck and Andrew L. Brasher, both appointed by President Donald Trump, described the program as racially exclusionary, concluding it would substantially likely violate the 1866 law if grants were awarded. The judges quoted Marshall's opinion in the 1976 McDonald case. The Supreme Court has held that Section 1981 was meant, by its broad terms, to prescribe discrimination in the making or enforcement of contracts against, or in favor of, any race. Colorblind Society. Legal scholars say the lawsuits citing the 1866 Civil Rights Act, as well as those that reference Title VII of 1964 Civil Rights Act, have a strong chance of eliminating race-conscious programs in the private sector. The lawsuits are aimed at wiping out any vestiges of what we call affirmative action in employment, said Susan Carl, a law professor at American University and an expert in Reconstruction-era history. The law is being used because it carries a constitutional overtone that could ripple into other areas of the law that protect private sector affirmative action and DEI programs, she said, adding, I very much fear that they will prevail. These lawsuits already are having an effect. After Bloom's group, the American Alliance for Equal Rights in August sued the Perkins Coie and Morrison Foerster law firms, both opened their diversity fellowships to law students from all backgrounds. The suits were later dropped. In October, Adams and Reese, another international law firm, discontinued its fellowship for minorities after Blum sent a letter threatening litigation. And Gibson, Dunn and Crutcher, one of the firms representing the Fearless Fund, has opened its diversity fellowship to all students. Neither had been sued. Last week, Bloom's group sued the law firm of Winston and Strawn, alleging its fellowship program discriminates against straight white men. These lawsuits are notable in an industry that has long struggled to diversify its workforce. Blacks represent less than 5% of practicing attorneys, according to the American Bar Association, compared with 14% of the U.S. population. The strategy being deployed by Blum, America First Legal, and other groups is a winning one, Rutherglen noted. It was pioneered at the advent of the civil rights movement by the NAACP Legal Defense Fund, which secured the landmark 1954 Brown v. Board of Education decision that ended segregation in schools. The fund's leader at the time, Thurgood Marshall, argued the case before the High Court. They're following the same strategies that Marshall followed, Rutherglen said. They're just doing it to pursue a conservative agenda. Darrell A. H. Miller, a law professor at Duke University, said there are a couple of ways to think about the 1866 law's arc. If you're a cynic, he said, it reinforces the idea that African Americans in particular would never benefit unless there's something in it for the dominant racial group. The less cynical view is one held by the High Court's conservative justices, Miller said, scratching the sore of Americans' sordid racial history never does anybody any good. And the way to stop discriminating on the basis of race is to treat every issue as if race didn't matter. I don't think that they have bad intent. I think they genuinely believe that a colorblind society will naturally and ineluctably lead to a more equitable society, Miller said. All I can say is, the history of America makes me somewhat skeptical. Trump and media want a televised trial in D.C. The Justice Department doesn't. The DOJ formally opposed a request to make the historic trial of a former president the first time federal courts allow TV cameras to broadcast or record a criminal trial. The Justice Department formally urged a federal judge Friday to reject calls by news organizations and by former President Donald Trump's defense to allow live television coverage of his federal trial in March on charges of illegally conspiring to subvert the results of the 2020 election, joining a potentially historic legal battle over public access to the federal courts. Last month, lawyers for a coalition of news organizations including The Washington Post and for the corporate parent of NBC News filed 2 petitions in Washington asking U.S. District Judge Tanya S. Chutkan to make an exception to the long-standing rule barring cameras from federal courtrooms for Trump's case and to permit the televising, recording, or same-day release of video and audio recordings of his trial. Since the founding of our nation, we have never had a criminal case where securing the public's confidence will be more important than with United States versus Donald J. Trump, attorneys for the 20-member News Coalition wrote in an October 5 application. They asserted that the trial of a former president and presumptive 2024 presidential nominee on charges of obstructing the most recent election presents the strongest possible circumstances for continuous public oversight of the justice system. In a separate sworn statement supporting NBC's request, Rebecca Blumenstein, the president of editorial for NBC News, urged the video recording of Trump's proceedings for posterity, saying, "It would be a great loss if future generations of Americans were forever deprived of being able to access and view the events of this trial even years after the verdict, which would immeasurably improve the ability of future journalists and historians to retell accurately and meaningfully analyze this unique chapter of American history." Trump's defense took no position on the media's request to the court, but his attorney John Lauro repeatedly called for the election subversion case to be televised before and after Trump's indictment, adding in a Fox News interview, And I would hope the Department of Justice would join in that effort so that we take the curtain away and all Americans get to see what's happening. Ordered by Chutkan to respond by Friday, prosecutors with special counsel Jack Smith said that the court's hands were tied, arguing that the media applicant's proposal is clearly foreclosed under Rule 53 of the Federal Rules of Criminal Procedure, which prohibits the broadcasting of judicial proceedings from the courtroom. Courts have long upheld the rule's constitutionality, and the federal judiciary reaffirmed the policy in criminal cases as recently as September. Assistant Special Counsels James I. Pierce and John M. Pelletieri wrote in an 18-page filing for the Justice Department, adding, "Whatever policy the applicants believe supports their requested relief is not properly directed to the court. This court should deny the applications." Since the dawn of the television age, federal courts have prohibited cameras in the courtroom, wary of feeding what the Supreme Court called in a landmark 1966 decision a carnival atmosphere of publicity that could intimidate witnesses, sway jurors, prompt grandstanding by attorneys or judges or deprive criminal defendants of their due process rights. That fear was exacerbated nearly 3 decades ago by the 9-month televised criminal trial and acquittal of retired football star O.J. Simpson on state murder charges in California. But leaps in technology, the recent coronavirus pandemic emergency and increasing experimentation by federal courts with live or recorded streaming of oral arguments have led some lawmakers and advocates to ask whether Trump's case might mark a fresh tipping point in the debate, or at least provide the impetus for incremental changes such as the archiving of video or the prompt release of audio recordings. I have my skepticisms about whether these courtroom camera efforts can prevail. But it is also unquestionably the case that the argument for cameras here is at its all-time strongest, University of Utah law professor Ronald Anderson Jones wrote in an email, adding, "It is hard to imagine any case or any defendant in the whole history of our federal courts that is as central to the public interest as this one." Jones said traditional concerns about creating a circus atmosphere or causing problems for witnesses or defendants can be addressed by limiting access to one camera or releasing footage after court approval. Audio streaming, she said, although it would rob the audience of the key visual cues and still give rise to misinformation-laden disputes about interpretation, would be another option that would at least give the general public more concrete information about what is happening. Trump has pleaded not guilty to an August 1 indictment accusing him of a criminal conspiracy to remain in office, obstruct Congress's lawful certification of Joe Biden's victory and deprive Americans of their civil right to have their votes counted. The case is one of 4 felony prosecutions launched this year against Trump. They include similar allegations by Georgia officials of trying to obstruct that state's election results. He also has been federally indicted in Florida over his alleged retention and mishandling of classified documents and obstruction after leaving the White House, and is accused in New York State of business fraud and covering up a hush money payment made during the 2016 election campaign. Trump's federal cases both fall under the rule barring televised courtroom proceedings. New York state courts have a similar ban, although acting New York Supreme Court Justice Juan M. Merchan permitted photographers to record still images before Trump's arraignment in April, over Trump's objections. By contrast, Trump's Georgia court is expected to permit telecasting of his trial, and it streams all hearings on the court's YouTube channel and permits a pooled news television camera in the courtroom. The News Media Coalition pointed out that Trump's Senate impeachment trial after the January 6, 2021, attack on the U.S. Capitol and hearings of the House Select Committee that investigated events surrounding the rioting were both nationally televised, drawing opening day television audiences averaging more than 11 million and 20 million, respectively, not counting online viewers. A legal team led by Charles D. Tobin, of the Ballard Spahr law firm, argued in a letter to the federal judiciary that with Trump himself campaigning for the presidency by claiming that his criminal prosecutions are election interference by prosecutors, allowing the public to see for itself would alleviate, not intensify, challenges to the legitimacy of the rule of law. If Americans do not have confidence that Mr. Trump is being treated fairly by the justice system, there is a very real chance they will reject the verdict, whatever it is, and that their faith in democracy and our institutions will be further diminished, Tobin and attorney Leda Walker wrote. Recent and painful events in our nation's capital show that, taken to an extreme, this sort of doubt and cynicism can lead to violence. Trump and the news media are not alone in seeking to speed change in the federal judiciary. Dozens of Democratic lawmakers and a spokesperson for the Republican-led House Judiciary Committee have said they support cameras in court in the limited but extraordinary circumstance of Trump's election obstruction case, and the full House has voted in the past for such changes. A bipartisan group of senators also introduced legislation this year before Trump's federal indictments to grant federal judges discretion to allow cameras while protecting the identities of witnesses and jurors. If the public is to fully accept the outcome, it will be vitally important for it to witness, as directly as possible, how the trials are conducted, the strength of the evidence adduced and the credibility of witnesses, Representative Adam B. Schiff, Democrat, California, wrote to the federal judiciary in August in regard to Trump's case. The pandemic did usher in revolutionary changes in federal and state courts, which were compelled to adopt live streaming because of pandemic restrictions on indoor gatherings that affected jurors, attorneys, court staffers, and the public. The Supreme Court began live streaming audio of oral arguments, and all federal appellate courts, including the one in D.C., make audio of oral arguments available online. Under since-expired federal pandemic emergency legislation, U.S. trial courts around the country also allowed federal criminal proceedings to take place by video or audio conferencing, with many allowing the public to access the proceedings by phone or online. In a milestone proceeding, the televised state trial of former Minneapolis police officer Derek Chauvin, who was found guilty of murder and manslaughter in the death of George Floyd, won praise from many past critics of the exclusionary practice. The Minnesota Supreme Court afterward granted all district courts in that state broad discretion to allow video coverage of most criminal trials. Even hardcore opponents became converts. Jane E. Kirtley, a professor of media ethics and law at the University of Minnesota, wrote in an email. Yet, Kirtley said, while it was her sincere hope that U.S. courts would go along at least with audio live streaming, I cannot be optimistic, given the federal judiciary's implacable and long-standing opposition. Judges don't like to give up control, and they see cameras in the court as the camel's nose under the tent, she said. The Federal District Court in Washington, no stranger to high-profile cases, for nearly 2 decades has offered live closed-circuit transmission of video taken from the courthouse's own cameras to nearby overflow rooms used by the public and media to permit electronic note-taking and live written and online reporting, but not recording or rebroadcast, showing that changes are possible. Still, advocates face an uphill fight. On October 26, a rulemaking panel of the national policymaking body for the federal courts denied the request by Media Coalition lawyers to exempt Trump's case from Rule 53. An advisory panel to the Federal Judicial Conference found it has no authority to grant exceptions to clear-cut rules, as first reported by Politico. But the panel agreed to create a subcommittee to consider a future rule change that would allow exceptions in extraordinary cases or at a judge's discretion. Changing a rule under a process set by federal law generally takes 3 years and requires public comment and the approval of the panel, the full conference of federal judges, the U.S. Supreme Court and Congress. This article has been updated to reflect that while Trump's attorney in interviews has called for his trial to be televised, prosecutors in their Friday motion stated that his defense requested that they convey that it took no position on the media request to the court. Testifying in fraud case, Trump clashes with judge and draws reprimands. New York, for years, Donald Trump has responded to investigations and governmental scrutiny with a mixture of bravado and combativeness, often lobbing his rhetoric across rally stages and social media. On Monday, though, the former president brought that bombast to a courtroom where government officials questioned him at length in a public setting. Testifying in a $250 million civil trial where he and his business are accused of a years-long fraud, Trump defended his company, lashed out at the case and his inquisitors, and clashed with the judge. This is not a political rally, New York Supreme Court Justice Arthur Engoron said, urging one of Trump's attorneys to control him. This is a courtroom. New York Attorney General Letitia James, Democrat, last year sued Trump, his adult sons, and their namesake company, accusing them of dramatically inflating the values of real estate properties to get better financial terms with banks and insurers. Engoron already ruled before the trial that Trump and his company broadly committed fraud. He is hearing the case without a jury and will determine whether specific illegal acts occurred in the process and decide any potential penalties. Trump, the leading candidate for the Republican presidential nomination next year, has repeatedly assailed James's case, denied any wrongdoing and insisted that he is being targeted for political reasons. Testifying for hours Monday, he delivered often extended, meandering remarks, touting his business acumen and slamming the judge. He ruled against me without knowing anything about me. He ruled against me and said I was a fraud before he knew anything about me, Trump testified, raising his voice. The fraud is on the court, not on me. James is seeking to have Trump and his business pay at least $250 million in penalties and wants them blocked from doing business in New York State. Trump is also separately facing a whirlwind of legal peril, with criminal cases pending against him in New York, Florida, Georgia, and Washington. He has said repeatedly that all of these cases are meant to damage him electorally. James's lawsuit has plainly irritated Trump, who has long promoted himself as a successful businessman. He has been under no obligation to attend the trial since it began last month, except for his testimony, but he has shown up in person several times and criticized James and the lawsuit. In her lawsuit, James alleged that Trump and his executives knowingly misstated the values of their assets along with other data points, such as the square footage of properties. James and her team say Trump and the company inflated these figures in financial statements submitted to banks and insurance companies over multiple years. Trump's side has argued that no fraud took place and that real estate valuations are subjective. His attorneys also argued that lenders did not rely on these statements. Before Trump's testimony began, James told reporters she was certain that he will engage in name-calling and taunts on the stand. She also pointed to a core issue in the trial, saying Trump has repeatedly and consistently misrepresented and inflated the value of his assets. Trump also spoke to reporters before going into the courtroom, criticizing James again and insisting that he was facing political attack ads by the Biden administration. Trump's adult sons, who are also defendants in the case, testified last week in the trial, and both sought to distance themselves from the financial statements, saying they trusted the company accountants who assembled them using information provided by the company. They are expected to be called to testify again by their own attorneys later in the case. Ivanka Trump, one of their sisters, who was dismissed as a defendant over the summer, is scheduled to testify Wednesday. During his testimony Monday, the senior Trump cycled through a range of expressions and behaviors. He alternately appeared boastful and frustrated, proud and irritated, bored and distracted. His tangents and remarks often hewed to by now familiar topics. He talked about his luxurious properties, described how good a company I've built and repeatedly defended his net worth. While questioned by Kevin Wallace, an attorney with James's office, Trump said his net worth was far greater than the financial statements, so I don't know what you're getting at, but go ahead. At another point, he maintained that his wealth was higher than what was reported in the financial statements because his accountants did not factor in his brand value. I became president because of my brand, Trump testified. Trump has answered questions in the case before, albeit not publicly. In April, he was deposed by James's office, and he said his financial statements come with disclaimers that other people might come to different conclusions about the value of his assets. During his deposition and on the witness stand Monday, Trump argued that disclaimers included by his accountants were a signal to lenders that they should do their own evaluations. On Monday, Trump repeatedly said that even if the statements were problematic, he was insulated from blame. I think the statements of financial condition were very good, were actually somewhat conservative and in some cases very conservative, he said. But regardless, he said, he's totally protected by the disclaimer clause that warned banks to go out and do your due diligence and to do their own analysis. His testimony also included courtroom insults aimed at James, such as a remark accusing her of watching every little move he made on the stand. Trump's appearance on the witness stand also included numerous rebukes from Engoron, beginning within 10 minutes of the start of his testimony. Trump quickly began complaining about the Democratic law enforcement officials who have investigated him. Engoron told Trump to refrain from making extraneous comments and just answer the questions, no speeches. Trump grumbled at one point that Engoron was ruling against me, because he always rules against me. Following another diatribe from Trump, the judge encouraged Christopher Kise, one of his attorneys, to have a talk with Trump about his behavior. Mr. Kise, can you control your client? He asked. Kise pushed back, though, saying that the former and again soon-to-be commander-in-chief understood the rules of a courtroom and did not need further instruction. Engoron later suggested he might remove Trump from the stand if he could not answer questions directly. He then raised his voice while addressing Trump's attorneys, who had stood up to argue that Trump should be able to make his case without restriction. Kise repeatedly called it a unique situation and asked for Trump to have leeway in speaking. His voice booming through the courtroom, Engoron told them to sit down. Soon after, Trump said from the stand, "This is a very unfair trial. Very, very. And I hope the public is watching." Engoron also seemed to needle Trump on Monday. Trump had complained about the judge's pretrial ruling, and Engoron said Trump should read my opinion again before adding, or for the first time, perhaps. "You're wrong in the opinion," Trump responded. "It is rare for a defendant to criticize a judge from the witness stand," said Chris Mate, an attorney from the firm Koskoff and Bieder. Mate represented the parents of children slain in the Sandy Hook massacre in a defamation lawsuit they filed against Alex Jones. In that case, Jones also repeatedly belittled the judge and the case outside the courthouse and online. "Jones and Trump were both playing to an audience," Mate said. "Their objectives are different than a normal defendant. A normal defendant would be doing everything he or she could do to avoid the legal penalty. Most judges aren't likely to be influenced either way by such attacks," Mate said. "Judges," he said, "really are required to set aside any personal feelings they may have and do their jobs. The jousting with the judge should not help his legal case," said New York University law professor Marcel Cahan. "It may hurt it if the judge feels that Trump is not answering the questions or not answering them truthfully. Whether it helps him politically is of course a different issue." Trump has already run afoul of Engoron, who last month issued a limited gag order blocking him from commenting on the judge's staff. That came after Trump posted on social media about the judge's law clerk and included a photo. Engoron has twice fined Trump for violating his order, for a total of $15,000. On October 25, he unexpectedly summoned Trump to the witness stand to explain some of his comments. After Trump was on the stand for a few minutes, Engoron promptly said he did not find him credible and fined him $10,000. Trump finished his testimony Monday afternoon, and his attorneys did not cross-examine him. After his testimony, James spoke to reporters and said Trump rambled and hurled insults. "But we expected that," she said. At the end of the day, the documentary evidence demonstrated that in fact, he falsely inflated his assets to basically enrich himself and his family. He continued to persistently engage in fraud. The numbers don't lie. Kise also spoke to reporters, saying the former president told everyone the facts, while Trump dismissed the case as a scam and defended his business practices after leaving the courtroom. "Everything we did was absolutely right," Trump said. Berman and O'Connell reported from Washington. Megan Vasquez in Washington contributed to this report. Trump, his adult children expected to testify in New York fraud trial soon. The former president, Donald Trump Jr., Eric Trump and Ivanka Trump will likely be called to the stand in coming days. New York, Donald Trump and 3 of his adult children are scheduled to testify between November 1 and November 6 in the $250 million civil fraud case that alleges years of financial misconduct by the Trump Organization and those who run it. The announcement of the Trump family's upcoming courtroom appearances was made on Friday after New York Supreme Court Justice Arthur Engoron ruled that Ivanka Trump, who is no longer a named defendant in the case, may be called by attorneys from the Office of New York Attorney General Letitia James to testify under subpoena. The former president, who is a named defendant along with Donald Trump Jr. and Eric Trump, is slated to be the last of the 4 Trump family witnesses, expected to take the stand on November 6, the day before Election Day. Trump is running for president again in 2024, and currently has a wide lead over the rest of the Republican pack. Donald Trump Jr. and Eric Trump, both executives at the Trump Organization, will testify on James's direct case on Wednesday and Thursday, respectively. The former president and his sons are expected to be called by their attorneys a second time later in the trial, which opened October 2 and could continue until nearly the end of December. Ivanka Trump, who is no longer actively involved in Trump Organization business, is scheduled to testify Friday, November 3. Her attorney could appeal Engoron's decision, potentially stalling her appearance. James's lawsuit alleges that the company and its executives purposely inflated the value of Trump's net worth by up to $2.2 billion from 2011 to 2021 to get better loan rates from lenders and lower insurance premiums. The company and the Trump family have denied wrongdoing. Ivanka Trump was dismissed from the case in June by an appellate ruling that said her involvement in the business transactions at issue was Trump has made multiple appearances already to observe the trial, which will be decided by a judge and does not include a jury. Most recently, he sat at the defense table on Wednesday, when his former advisor and attorney Michael Cohen testified against him. On that day, Trump was fined $10,000 for making a statement in the hallway that appeared to accuse Engoron and his law clerk of being overly partisan. After Trump had posted about the clerk on social media earlier in the trial, Engoron imposed a gag order barring Trump from making comments about the judge's staff. Trump Jr. tells court artist, "Make me look sexy," points to fake SBF sketch. As former President Donald Trump's sons took the stand in the civil fraud trial against their family business, Donald Trump Jr. made a forward request to the sketch artist capturing his image and likeness in the courtroom. "Make me look sexy," he said. After Trump Jr. finished his Thursday testimony on the financial statements at the heart of the $250 million lawsuit, he approached courtroom sketch artist Jane Rosenberg and asked whether she could draw him in an overly flattering way. Rosenberg was on assignment for Reuters, the first to report on the exchange. Trump Jr. had an example of what he should look like, and it came from another Manhattan courtroom. Rosenberg said he pulled out his phone and showed her the fake courtroom sketch of Sam Bankman-Fried, the FTX co-founder who faces decades in prison after he was convicted of fraud, conspiracy, and money laundering on Thursday. He said, "Did you see the one they made of Sam Bankman-Fried? It made him look like a superstar," she recounted to Insider. Rosenberg told Reuters she quickly shot down the AI-generated sketch of Bankman-Fried, depicting him as having spiky hair and a firm jaw instead of his usual disheveled self, as being fake. "It doesn't look anything like him, doesn't look anything like Sam Bankman-Fried," she said, "and there's no one in the Rosenberg, a veteran courtroom artist who has drawn sketches of everyone from Tom Brady to Harvey Weinstein, depicted Bankman-Fried throughout his trial as having big ears, a protruding forehead and bulging eyes. Rosenberg did not immediately respond to a request for comment early Friday. Trump Jr. confirmed on X that he asked the artist to make him look good in his courtroom sketch. "True story," he wrote, sharing a side-by-side comparison of the fake courtroom sketch and a real photo of Bankman-Fried. "Seems like a reasonable ask." Trump Jr.'s sketch request comes as attorneys for New York Attorney General Letitia James, Democrat, have accused the former president, his sons, and their eponymous company of inflating the financial statements to secure better terms. The trial is examining the alleged long-standing practice by the Trump Organization and its executives that was done to negotiate better interest rates from lenders and to cut down on insurance policy costs. As he was questioned by Colleen Faherty, a member of James's trial team, Trump Jr. testified that he was not involved in the accounting that went into the financial statements, describing that as the work of the company's accountants. The former president's namesake mentioned to Rosenberg how he wanted a flattering sketch like Bankman-Fried's hours before the FTX co-founder was convicted. The jury's decision was reached after less than 5 hours of deliberation, with Bankman-Fried being found guilty on 2 counts of wire fraud, 4 counts of conspiracy to commit fraud and 1 count of conspiracy to commit money laundering. The attorney for Bankman-Fried, who is accused of being one of the largest financial fraudsters in history after victims suffered nearly $10 billion in losses, suggested that his client will appeal the conviction. Bankman-Fried's sentencing is scheduled for March 28, 2024. Rosenberg is among the most well-known courtroom sketch artists in America. In the decades after she got her start drawing prostitutes in New York's night court, Rosenberg has captured the likes of Ju.dy, Woody Allen and Martha Stewart while they were on trial. Rosenberg faced some criticism a few years ago for her depiction of ugly Tom Brady during a Deflategate hearing in 2015. Her rendering of the New England Patriots quarterback made Brady, known for his handsome features, look as if he had gone through a gruesome transformation. The sketch caused a firestorm of internet memes and a deluge of nasty emails from Patriots fans. Rosenberg is also no stranger to sketching a member of the Trump family in court. When the former president was arraigned in April on 34 counts stemming from 2016 hush money payments, Rosenberg drew sketches showing Trump's anger after the first criminal charges were handed down to any former U.S. president. The sketch went viral and graced the cover of The New Yorker. In the days before Bankman-Fried's conviction, a fake courtroom sketch of him spread online that depicted him to be an Adonis, or at least an underwear model. The internet had fun over the AI-generated rendering. Why does courtroom sketch SBF look like? But the fake sketch of Bankman-Fried rankled Rosenberg, who maintained to The Independent that the AI-generated image doesn't look anything like him. Rosenberg acknowledged to the British outlet that the courtroom sketch artists said the AI image looked more like Matthew Perry, the Friends star who recently died, than Bankman-Fried. "It's not Bankman-Fried, it's not his nose, it's not his face, it's not anything," she said. "You know that AI doesn't work in courtroom art." She added, "It's so silly, this whole world of Twitter. So we're talking about nothing." Rosenberg's courtroom depictions of Bankman-Fried changed during the course of the month-long trial, with some comparing his droopy and unsettling features to that of the Scream, the 1893 composition by Edvard Munch that symbolizes the anxiety of the human condition. Like any of her other sketches, including Trump Jr., Rosenberg told The Independent that her process for drawing the real sketch of Bankman-Fried was simple, and that it wasn't her job to analyze whether defendants were tragic figures. "I just look at him and draw what I see," she said. Shayna Jacobs, Mark Berman, Eli Tan, and Tori Newmier contributed to this report. Trump Jr. testifies, deflects responsibility in New York business fraud case. New York, Donald Trump Jr. testified Wednesday afternoon in a multimillion-dollar civil case that accuses him, his father and other Trump Organization executives of cheating in business deals, saying he was not directly involved in the production of financial statements. The former president's son is the first member of his family to be called as a witness by the Office of New York Attorney General Letitia James, Democrat, in its $250 million fraud lawsuit against the family and the company. James's lawsuit accuses Donald Trump and his executives of inflating his financial statements to secure better terms. During his testimony, Trump Jr. said the responsibility of preparing financial statements rested with Mazars USA, the company's longtime accounting firm. "These people had an incredibly intimate knowledge, and I relied on them," Trump Jr. said. His testimony marked the beginning of a new, more high-profile phase in the trial, in which multiple members of the family, including Trump, are expected to take the witness stand in the coming days and address the allegations against their company. Trump Jr. is one of the defendants in the trial, which began on October 2. He is expected to continue testifying Thursday and is also expected to be summoned back to the stand later in the case by his own attorneys. His brother Eric Trump, also a defendant in the case, is scheduled to testify on Thursday as well. Their father is set to testify Monday, followed by their sister Ivanka Trump 2 days later, though she is appealing an order directing her to take the stand. The family's dynamics and business's practices are expected to be on display in the coming weeks as they and the Trump Organization as a whole face scrutiny in a Manhattan courtroom. James's lawsuit alleges that Donald Trump, his executives, and his adult sons committed a decade-long fraud to inflate his net worth by billions to get better rates from lenders and insurance firms. The Trump family and their lawyers have denied any wrongdoing, with the defense maintaining that there was no fraud committed. Defense attorneys have said that real estate valuations are subjective and that lenders did not rely on Trump's annual statements of net worth to make their decisions on loans. Trump Jr., and Eric Trump, who is running the company, remain defendants in the case, while Ivanka Trump was dismissed as a defendant in an appellate decision in June. Before the trial, New York Supreme Court Justice Arthur Engoron ruled that the defendants and the company broadly committed fraud. The trial, which will be decided by the judge and not a jury, is examining whether the defendants committed specific illegal acts in the course of committing fraud. The case has the potential to essentially stifle Donald Trump's ability to conduct business in New York, by restricting the ability of officers to do their jobs and by preventing the company from obtaining new loans and from acquiring new properties. It is a civil case, not a criminal one, so no one involved faces any time behind bars as a result. When he took the stand Wednesday, Trump Jr. discussed his background, including his education and work with the Trump Organization. During his testimony, Trump Jr. said he had no significant knowledge of the accounting standards known as the Generally Accepted Accounting Principles, GAAP. Evidence at the trial has shown that financial statements prepared by the Trump Organization and distributed to business partners between 2011 and 2021 did not comply with those rules. I have no understanding of accounting guidelines. That's what we have CPAs for, Trump Jr. said, referring to certified public accountants. Trump Jr. arrived in the courtroom with a confident stride Wednesday afternoon. While his testimony got underway, he avoided the more bombastic stance he has displayed on social media and in television interviews. He maintained his composure on the stand, though his patience seemed to wane as the questions continued throughout the afternoon. Leaving the room during an afternoon break, he paused to hover over the courtroom sketch artist's work, looking at her drawing of him. Trump Jr. and Engoron shared a laugh Wednesday over his testimony that he knows nothing about accounting rules. His only knowledge of GAAP, Trump Jr. said, is that it covers common accounting procedures. He learned that in his Introduction to Accounting course at the Wharton School years ago, he said. Trump Jr.'s father was called to the witness stand briefly last week for a much less lighthearted moment. Donald Trump was summoned in an impromptu hearing over whether he had violated a gag order Engoron imposed barring him from making public comments about the judge's court staff. The limited gag order in the case came after Trump had posted to social media about a member of the judge's staff, including a photograph. Then, last week, Trump spoke to reporters in the hallway outside the courtroom, as he often does, and assailed Engoron, a Democrat, as a very partisan judge. He also said there was a person who's very partisan sitting alongside of him, perhaps even more partisan. Engoron soon summoned Trump to the stand. Trump said his remark was not about one of the judge's staff members, but instead was aimed at Michael Cohen, a Trump attorney turned nemesis who testified earlier that same day. Trump said he was talking about Cohen, but then added of the staff member that he felt she was very biased against us. Engoron said he did not find Trump's defense credible, fining him $10,000. Trump has appeared at the civil trial several times, even though he isn't required to do so. He has grimaced during testimony, delivered campaign-style remarks to reporters outside the courtroom and complained repeatedly on social media about what he claims is improper meddling in his private business affairs by James, a Democrat. Trump, who is seeking the 2024 GOP presidential nomination, is facing 4 criminal prosecutions in other jurisdictions. He has insisted he is being targeted for political reasons. He has also criticized Engoron, calling him a political hack and protesting that some of his offspring have to appear in court. "Leave my children alone, Engoron," Trump posted on social media early Wednesday. "You are a disgrace to the legal profession." Berman reported from Washington. Supreme Court skeptical of lawyers' claim to phrase Trump too small. Supreme Court justices across the ideological divide seemed skeptical Wednesday that a California lawyer has a free speech right to trademark the double entendre phrase Trump too small for use on t-shirts, criticizing former President Donald Trump. In fact, Chief Justice John G. Roberts Jr. opined, ruling for Trump critic Steve Elster could make it harder for others to create their own takes about the man running to reclaim his old job. Presumably, there will be a race for people to trademark, Trump to this, Trump to that, whatever, the conservative Roberts told Elster's lawyer, Jonathan E. Taylor. That could put off-limits political expression other people might regard as important infringement on their First Amendment rights. The debate among the justices mostly concerned how the court could rule for the U.S. Patent and Trade Office, which said Elster's request violated a law disallowing trademarks that use a person's name without their consent, but not impose unwanted consequences for other areas of the law, such as copyrights for book titles that use a person's name. The bottom line, Justice Sonia Sotomayor said, was that Elster did not suffer an injury when his trademark request was denied. The question is this an infringement on speech? And the answer is no, the liberal Sotomayor said, adding that the government is not telling him he can't use the phrase, just that he can't trademark it. There's no limitation on him selling it. So there's no traditional infringement. Indeed, the shirt is widely available to order on the internet. The phrase draws from a locker room taunt during the 2016 presidential campaign. Tired of Trump's use of Little Marco, Senator Marco Rubio, Republican, Florida, mentioned the size of Trump's hands during a campaign stop. "You know what they say about men with small hands," Rubio told a crowd in Salem, Virginia, in February 2016, pausing to let the audience laugh. You can't trust them. Trump responded during a televised presidential debate days later with a remarkable claim that drew headlines unseen in any previous presidential campaign. "Look at those hands, are they small hands?" Trump said, raising them for viewers to see. And, he referred to my hands, if they're small, something else must be small. I guarantee you there's no problem. I guarantee. Elster wanted to trademark the Trump too small phrase to criticize the size of Trump's package of policy proposals. A unanimous panel of the U.S. Court of Appeals for the Federal Circuit ruled in his favor last year, saying the prohibition on violating a person's privacy was outweighed by Elster's First Amendment right to criticize public officials. The government has no valid publicity interest that could overcome the First Amendment protections afforded to the political criticism embodied in Elster's mark, wrote Judge Timothy B. Dyke. As a result of the president's status as a public official, and because Elster's mark communicates his disagreement with and criticism of the then-president's approach to governance, the government has no interest in disadvantaging Elster's speech. The case is the latest to come before the Supreme Court involving challenges to trademark denials. In each of the previous cases, those seeking registration successfully argued that the government was wrong to reject their requests as offensive. In Madel v. Tam, government officials refused an Asian American band's request to trademark their name The Slants, saying it would violate a ban on disparaging marks. In Ivanka v. Brunetti, the trademark office denied registration to clothing company FUCT because of a prohibition on immoral or scandalous marks. Trump is not a party to the current suit, and his privacy was defended by the Biden administration. Career Justice Department lawyer Malcolm L. Stewart, arguing his 100th case before the court, made the case that a trademark is a benefit awarded by the government, and consent by an individual to use of his or her name is not an undue burden on speech. The living individual clause simply restricts Mr. Elster's ability to assert exclusive rights in another person's name, he said, and is viewpoint neutral. Even if the justices seemed generally to think the government should prevail, some looked for an easier way to rule than deciding whether a trademark was a benefit the government was free to restrict. The extent of the government's authority to attach conditions to government benefits is a very difficult area of constitutional law and potentially quite a dangerous one, said Justice Samuel A. Alito Jr., who had made a similar argument in the court's previous considerations of trademark law. Perhaps our precedent should be extended to cover this situation, but this is quite unlike any of the other cases that we have had concerning that. Justices Clarence Thomas and Amy Coney Barrett pressed Stewart about how his argument might affect copyright law, which doesn't require a person's consent. Let's imagine that there's a similar restriction for copyright and somebody wants to write a book called Trump Too Small that details Trump's pettiness over the years and just argues that he's not a fit public official, said Barrett, who coincidentally was Trump's third and final appointment to the Supreme Court. Are you saying, she asked Stewart, that the government could restrict the author from using Trump's name? Stewart said he thought it possible to make distinctions. Copyright law has historically been viewed as the engine of free expression, Stewart said, while trademarks have been seen as necessary to foster the free flow of commerce and to allow consumers to recognize which goods are manufactured by which merchants. Barrett did not seem persuaded, but Elster's lawyer Taylor had the harder outing. He told the court that the government's sole interest in denying the trademark is protecting the feelings of famous people. But that is not a legitimate reason to burden protected speech. But Thomas pressed Taylor to detail what speech precisely is being burdened. When Taylor said Elster was being denied government protection that is routinely given to others, Sotomayor said he seemed to be making the government's case that the decision was about a restriction on benefits, not on speech. After additional questions, Justice Elena Kagan told Taylor she did not want to badger you or anything. But she said he had failed to find a case supporting his proposition that when the law does not favor one viewpoint over another, government cannot make distinctions when government is only giving out a benefit and not restricting any speech. The case is Vidal v. Elster,